50 Real estate law terms every agent should know. Agency, which means a legal relationship in which an agent represents a client in a transaction. For example, the agent owes fiduciary duties to the seller they represent. Fiduciary duty, which means the legal obligation to act in the best interests of a client. For instance, a buyer's agent must disclose all known property defects to their client. Dual agency, which means when one agent represents both the buyer and seller in the same transaction. For example, in some states, dual agency is legal if both parties give written consent. Disclosure, which means the act of providing all relevant facts about a property to the other party. For instance, sellers must disclose known water damage to potential buyers. Material fact, which means any fact that could influence a buyer's or seller's decision in a transaction. For example, the presence of asbestos in a home is a material fact that must be disclosed. Caveat emptor, which means let the buyer beware, the principle that buyers must do their own due diligence. For instance, in some states, sellers aren't required to disclose minor defects, so buyers must inspect. Earnest money deposit, which means a sum of money a buyer provides to show good faith in purchasing a property. For example, the buyer placed $5,000 in escrow as an earnest money deposit. Escrow, which means a neutral third party holds funds and documents until all conditions are met. For instance, the escrow company released the funds once the title was clear. Contingency, which means a condition that must be met before a contract becomes binding. For example, the purchase agreement had a financing contingency for the buyer's loan approval. Breach of contract, which means failure to fulfill the terms of a legally binding agreement. For instance, if a seller backs out without cause, they may be liable for breach of contract. Specific performance, which means a legal remedy requiring a party to fulfill their contractual obligations. For example, the court ordered specific performance, forcing the seller to complete the sale. Statute of frauds, which means a law requiring certain contracts, like real estate sales, to be in writing to be enforceable. For instance, a verbal agreement to sell a house is unenforceable under the statute of frauds. Title, which means legal ownership of property. For example, the buyer received the title after closing. Deed, which means a legal document that transfers property ownership from one party to another. For instance, the seller signed the warranty deed to convey the property to the buyer. Warranty deed, which means a deed guaranteeing the seller holds clear title and has the right to sell. For example, the buyer preferred a warranty deed for maximum protection. Quitclaim deed, which means a deed that transfers any ownership interest without guarantees. For instance, the ex-spouse signed a quitclaim deed to remove their name from the property. Lien, which means a legal claim against property for payment of a debt. For example, the lender placed a lien on the property until the mortgage is paid off. Mechanic's lien, which means a lien filed by contractors or suppliers who haven't been paid for work on the property. For instance, the homeowner had to resolve a mechanic's lien before selling. Mortgage, which means a legal agreement in which property is pledged as security for a loan. For example, the buyer obtained a 30-year mortgage to finance the purchase. Promissory note, which means a written promise to repay a loan under specific terms. For instance, the borrower signed a promissory note agreeing to pay monthly installments. Foreclosure, which means the legal process by which a lender takes back property due to loan default. For example, the bank began foreclosure after 6 missed mortgage payments. Short sale, which means selling property for less than the mortgage balance with lender approval. For instance, the homeowner pursued a short sale to avoid foreclosure. Eminent domain, which means the government's right to take private property for public use with compensation. For example, the city used eminent domain to expand a highway. Zoning laws, which means local regulations controlling land use. For instance, the property was zoned for residential use, not commercial. Variance, which means permission to deviate from zoning regulations. For example, the owner applied for a variance to build closer to the property line. Easement, which means the right to use another person's property for a specific purpose. For instance, a utility company had an easement to run power lines through the yard. Encroachment, which means unauthorized intrusion onto another's property. For example, the neighbor's fence was an encroachment onto the seller's land. Restrictive covenant, which means a deed restriction limiting property use. For instance, the HOA's restrictive covenant prohibited chain-link fences. HOA bylaws, which means rules governing a homeowners association. For example, the HOA bylaws required approval for exterior paint colors. Adverse possession, which means acquiring title to property by continuous, open, and hostile possession. For instance, the neighbor claimed adverse possession after occupying the land for 15 years. Recording, which means filing documents with the Public Records Office to establish legal priority. For example, the deed was recorded to show the buyer's ownership. Title insurance, which means insurance protecting against title defects. For instance, the buyer purchased title insurance to protect against future ownership disputes. Cloud on title, which means any claim or defect that could affect ownership. For example, an old lien created a cloud on title that needed resolution before closing. Deed in lieu of foreclosure, which means transferring property to a lender to avoid foreclosure. For instance, the borrower gave the bank a deed in lieu of foreclosure to settle the debt. Joint tenancy, which means co-ownership with equal shares and right of survivorship. For example, when one joint tenant died, the other inherited their share automatically. Tenancy in common, which means co-ownership without the right of survivorship. For instance, each tenant in common could sell their share independently. Life estate, which means ownership lasting for the duration of someone's life. For example, the seller retained a life estate and continued living in the home. Lease agreement, which means a contract granting the right to use property for a specified period. For instance, the tenant signed a 1-year lease agreement for the apartment. Sublease, which means leasing property to a third party while still holding the original lease. For example, the tenant subleased the unit while studying abroad. Security deposit, which means money held by a landlord to cover potential damages. For instance, the landlord returned the tenant's security deposit after the lease ended. Option to purchase, which means a contract giving a party the right, but not the obligation, to buy property. For example, the tenant had an option to purchase the home within 2 years. Right of first refusal, which means the right to buy property before the seller offers it to others. For instance, the HOA had the right of first refusal on any condo sale. Seller's disclosure statement, which means a form detailing known defects and property conditions. For example, the seller listed roof leaks on the disclosure statement. Lead-based paint disclosure, which means federal law requiring disclosure of lead paint in homes built before 1978. For instance, the agent provided the required lead-based paint disclosure to the buyer. Fair Housing Act, which means a federal law prohibiting housing discrimination. For example, refusing to rent to a family because they have children violates the Fair Housing Act. Americans with Disabilities Act, ADA, which means a law requiring accessibility for people with disabilities in certain properties. For instance, the commercial building installed ramps to comply with the ADA. Truth in Lending Act, TILA, which means a law requiring lenders to disclose loan terms and costs. For example, the lender provided a TILA disclosure showing the APR. Real Estate Settlement Procedures Act, RESPA, which means a law requiring disclosure of settlement costs and prohibiting kickbacks. For instance, the buyer received a RESPA settlement cost booklet before closing. Antitrust laws, which means laws preventing price fixing and unfair competition. For example, two agents agreeing to set minimum commission rates violates antitrust laws. Statute of limitations, which means the time limit for bringing legal action. For instance, the buyer had 4 years to sue for contract breach under the state's statute of limitations.